AM 1060 WMEL.
AM 1060 WMEL, your home for NASCAR.
The views expressed on the following program are those of the hosts, callers, and guests, and are not necessarily those of WMEL staff, management, or advertisers.
This is Joe Steckler, folks, your host for Helping Seniors. The mission of Helping Seniors is to inform, educate, and connect seniors and those that care for seniors to resources. The phone number to reach Kay Kaiser, our information specialist, is area code 321-473-7770. If you call Kay or call here at the radio station at 431-1060?
241-1060.
241-1060. I get it wrong every time, folks. Anyway, call radio station WML or K at 473-7770. Some of the sponsors for the first part of the show include Kindred at Home Healthcare, the Eye Institute, Dr. Lee Sheldon, Bill Johnson, attorney, my panelist today, this radio station, Wistoff Hospital Systems, Levin Home Care, Ebony News Today, Riverview Resort Area, and Organized Creatives Designs, which is a downsizing, helps seniors move out of where they are and into something different. Some of us want to change as we get older. As we get older, we don't need all the stuff we have. We don't need to take care of it. We can't take care of it. So we get rid of it. We'll do a show on that sometimes because I think we should do it. Folks, today, my panelist is Bill Johnson. Welcome, Bill.
Good morning, Joe, or afternoon.
No, it's afternoon. At least I know that much. Folks,
I was just checking you.
Yeah. I came out here with an idea on doing a show with Bill. And I wanted to call it Real Estate Planning. And I thought, gee, if we put real estate planning up on a network, what would people think we're talking about? And Bill said it confused him too. But I'm talking about estate planning that gets into the nitty-gritty nuts and bolts of estate planning. What are some of the things that good estate planning attorneys tell their clients to do or not do? Some of these things, we don't talk about them on the air. And just like we don't really talk about that current mess in Washington, D.C. on the air. But it does bother seniors. And Bill just told me something that just blew my mind completely because, you know, many of us think that we have a budget. And the budget is right now $20 trillion in debt. But it's actually worse than that because we haven't had a real budget passed and approved by the president in probably about a decade. We've just been going along on resolutions. So we don't really know what the debt is. And Bill just looked up the cost of sending the troops back into Afghanistan and
Well, I
Iraq.
was looking up what the cost of the Iraq War and the war in Afghanistan was. And it was something on the order between 4 and 6 trillion. I've seen other estimates from 4 to 7 trillion based on not only the cost of having the troops there, but the ongoing medical care. And that is not including all that's going on right now.
Yeah.
Okay, was the cost before. So the cost is still going up.
Bill, do you think, based on, these are things that people don't know. I didn't know it. I honestly believed that we were $20 trillion in debt. We could be $30 trillion in debt. We don't know.
True. And there are, all these actions that we're taking, those bombs, cruise missiles, something like, I think, $10 million a pop.
Yeah.
Yeah, I mean, so that gives you an estimate of, some of the costs we're involving here. I don't know how much an aircraft carrier costs per day to sit out in the Mediterranean or the Persian Gulf, but that's got to be enormous too.
Well, it used to be in the billions. Now I got a feeling it's close to $1 trillion now. So, I guess what I'm talking about, folks, is what we don't know. I pulled a document off Bill's network that goes out to the National Association of Elder Law Attorneys.
Well, I think what we were talking about is at some point you're going to run into a guns or butter kind of argument. Where do you want the national monies to go into? Continuing to pay for these overseas excursions or taking care of people here at home? And the reason I think we brought that up was because there are several legislators proposing expanding Medicare to cover hearing aids. And we were talking about how the cost of hearing aids is, like $3,000 for one of them.
The average cost is $2,300 to $2,800 for one hearing aid, and many people can't afford two, so they just have one hearing aid. But what's ironic, Bill, is that when we passed the Social Security Act in 1965, they had an amendment to that excluded providing hearing devices and a couple other forms of dental care and a couple other things that were very costly that they knew that people absolutely had to have. Because I read another report to the president that said the 80% of the people over the age of 79 would have severe hearing loss. And now they're trying to get hearing devices put back into the Social Security thing, and right now Social Security, as currently constituted, is scheduled to deplete in 2034.
And so what we were talking about is how this would just simply hasten that. If you started buying hearing aids for all the seniors, you're talking about a huge expenditure of the Medicare funds, and how that might hasten the whole program's demise, which of course led us to the discussion about how much we were spending on wars.
Exactly right, because it all comes up. Folks, since Bill is an attorney, I asked Bill a question about, and this I think what we're talking about is germane to the topic of helping seniors. It is germane that we all understand where the money is going and why we need to be concerned about this. Because I asked Bill a basic question about signing a piece of paper saying, I understand what it means to safeguard confidential documents. Folks, I spent 38 years in the military, and I saw careers ruined because some officer may have lost a single page out of a top secret book or a secret book or even confidential material, folks. And in the early days, it was that serious. And I know of these cases. I've seen them. So I know what I'm talking about. I'm not lying. I'm not a Republican or Democrat. I'm telling you based on personal experience. And for anybody to stand up for the country and say that I didn't know that I had top secret documents when I read them, that's just lying. Bill?
Well, I think the record speaks for itself. I mean, she turned over the emails, and certainly they reviewed those and did find some of them to be classified, and even some marked as classified. But I think the point you wanted or asked me is, how could they possibly not prosecute her?
Right, exactly right.
And the point I raised to you is, it's not, I've seen on Facebook and elsewhere where people are simply just posting the statute. And if you know anything about law, well, we live in a common law society where not only do we look at the statute, but we also look at precedent, what the case law says. And this gentleman, Comey, is a prosecutor. And from what I can understand, he's a very straight shooter. And he had a team, and they all looked at not only the statute, but what all the other material being the case law said about this. And he didn't think any prosecutor in their right mind would take this case and try it. He didn't think it was something that was
cut and dried.
Yeah, prosecutable.
Right.
And we have talked, I think, even on the air about your situation where somebody did identity theft.
Right.
And you went around to all the state attorneys trying to get them to prosecute this person. and nobody wanted to prosecute it because
Exactly right.
even though there was some evidence and some very strong evidence, you and me thought, they didn't want to, the likelihood, I guess, they thought of getting a conviction was slim. So not only do you have to have something that that may or may not be a crime, but you also have something, if you're going to go to court, that you think you're going to win.
Yeah.
And you have to take not only the statute, but also the case law and how judges have ruled in the past.
And
on
that's
these things.
but it's a hard, bitter pill for people to swallow, Bill.
Well, I guess depending on which side of the aisle you sit.
Well, yeah, I sit on the aisle of just 38 years.
Because what I've been seeing is that there's a whole slew of Republicans who have been lauding Comey as a great person to lead the FBI, straight shooter,
Yeah.
more law and order guy, doesn't let politics get involved in his job. And that was just what I heard on the radio on the way over here. And, so, now that he didn't, find in somebody's way or the way somebody wanted them to find, now all of a sudden they're throwing him under the bus. So, I don't know whether or not that is. I'm not the prosecutor. I don't get to see what he sees. I'm not on his team, so I'm going to defer to him.
Okay, let's take it back then and go back to something that you and
something less contentious.
Something less contentious. And
Okay.
let's go into the subject of what I talked about, estate planning. And, I always ask Bill about documents and stuff like that, but I want to start with what I have as my second question, Bill.
Let's start with that first one. I like that one.
Go ahead. Go ahead and define estate planning.
Well, Joe was talking, what he meant by real estate planning was a lot of people don't think about planning for what happens to the house. And when they're thinking about the house, they have some generally big misconceptions. And in Florida, we have a lot of very important laws that play in on your homestead. So let's first mention those.
Okay.
In Florida, we have generally three types of homestead. The first is that $25,000 you get off your appraised value for property taxes.
Right.
Okay. Everybody knows about that.
Right.
Everybody goes down there and runs down to the property appraiser's office, applies for that, and gets that.
And it's smart you keep it with your documents.
Yep. The second type of homestead is that your house, your residence, is free from creditors' claims, meaning no creditor can force you to sell your house unless it's a debt that's connected to the property. What are debts that are connected to the property? Well, the biggest one would probably be your mortgage. Second biggest would probably be your property taxes, meaning if you don't pay your mortgage, they can come take your house. You don't pay your property taxes, they can come take your house. Don't pay your homeowner or condo dues, they can foreclose. If you don't pay somebody who worked on your house and they perfect a mechanic's lien, they can foreclose on your house. And if you obviously don't pay your federal income taxes, they kind of trump everything and can come after everything.
Right.
But beyond that, you could have $500,000 in credit card debt. They can't touch your house. You could owe a nursing home $200,000. They can't touch your house. You could be on Medicaid for 10 years with a bill of $1 million to Medicaid. They can't touch your house. And that's because of our Florida Constitution. So if your neighbor's telling you that the nursing home's going to take your house or the Medicaid's going to put a lien on your house, well, that's not true in Florida. So that's one thing. We have creditor protection for our houses.
Right.
The third type of homestead in Florida is what we call the devise and descent homestead, and that determines who gets your house when you die. Now, if I own my house jointly with my spouse and I die, my spouse automatically gets the house. Okay? If, however, I own the house, let's say I owned it prior to being married, I get married, and we have a handshake, me and my wife, that she's going to leave all her stuff to her kids, and I'm going to leave it all to my kids. And then I die, and I haven't added her name to the house or anything. The state constitution will automatically step in and give her a life estate in the house, the homestead.
Give her a what now?
A life estate. That's the use of the house for her life.
Okay.
She doesn't even have to live in it. So she gets the use of the house for her life. And then upon her death, it would pass to my children.
Not hers.
Not hers. So
But she could take that house and rent it the whole time.
she could rent it. Yeah.
Sure.
She could do whatever she wants with it.
Okay.
So if I had done a simple will where I say I leave my house to my kids and I die, now we got a title problem because my will says it belongs to my kids and the Constitution says it belongs to my spouse. So generally speaking, my spouse will get that life interest. Now, a few years ago, they have changed the law that my surviving spouse can change from a life interest to a 50% ownership interest if they want.
What does that mean?
It means instead of taking that life estate, they can take a half ownership interest in the property.
So what would happen to the house?
So then if we were going to sell the house, then we would divide the proceeds 50-50.
So she would get 50% and heirs would get 50%.
Correct. And that's an election the surviving spouse has to make within 9 months. Now remember, if your spouse is on the deed and you die, they inherit the whole thing. So we're talking about if it's owned any way other than what they call tenants by the entireties, as husband and wife.
How many people, Bill, do you think, and you've worked with a lot of people in second marriages,
This is a classic one that trips up people in second marriages.
this does?
Yeah, because they never go consult with a lawyer before they get remarried. And so they don't know the repercussions because there are certain rights. There's another right that comes in if you get married. It's called the elective share. This one's not automatic, meaning if I was married to somebody and they pass and say all their assets are designated to go to their kids, as a surviving spouse, I can still go in and claim 30% of their estate. It's not automatic. I have to file with the court system, but I can go after 30% of the estate.
How do you think, you've heard the old expression, ambulance chaser.
Uh-huh.
How many people could you put in a category they might be called marriage chasers, doing exactly what you're just talking about?
That I've had some cases where that's been the case. I don't know how many people, but they are out there. I had a horrible case about 3 or 4 years ago where a lady purposely met some guy at a church function, and he was beginning to show signs of Alzheimer's, so knew he was an easy target and got in, married him, and immediately started having him change all the assets over to her name and changing all the estate planning to cut his kids out and leave everything to her. So, there are people out there who go do this. And there are people who do this very well.
Okay. Yet at the same time, I know of a case where the reverse happened, where the wife had shared with her husband in the second marriage, but the children of the first marriage tried to take everything from the wife of the second marriage.
Correct. I've had the reverse.
Yeah.
Exactly. In fact, I think I've talked to you about 80% or 90% of the litigation that we see usually involves kids from a prior marriage and a new spouse. I mean, that's usually where the friction is and where the conflict is. Now, that can all be avoided, at least on the estate planning end of things, by having a pre or a post-nuptial agreement.
So that's one of the advantages of talking to an attorney
Ahead of time.
ahead of the time.
Correct.
And the whole reason, folks, that we got into that discussion was because I asked Bill a question under what I meant by real estate planning, and Bill went to the house issue, and I wanted him, and we'll talk about it, and we'll talk about it. I don't think we'll finish it before the break, but we want to talk about what really could happen to the house, especially if we have a valuable house and a person goes in on Medicaid and somebody sells the house, you lose everything.
Which is a good conversation to have, because, as I told you, the house doesn't count as an asset for Medicaid, and they can't come after the house. So usually we want to keep the asset because homestead is a wonderful way to safeguard a large asset, probably your biggest asset.
If you want to help.
Yeah, but if you sell it and turn it into cash, then you may have to spend it down on your care before you qualify for Medicaid.
But what would happen if, let's say, you had an heir or had heirs that were on Medicaid themselves, and you give them a large sum of money? Would that constitute taking them off of Medicaid?
Yes, it would knock them out of the program.
How do you prevent something like that?
Well, what we do is you could give it to them in the form of having a special needs trust, where you don't actually give it to them, but they can get the use of some of that money.
They can get the use of some of it?
Mm-hmm.
Let's say if somebody gave somebody a special needs trust of $100,000.
Right. The trustee would then be able to buy things on behalf of the people, but he just wouldn't be able to give them cash.
Okay, we're too close to the break, folks. I want to pick up on that one on the other side of the break, because that's something important, because it happens to people all the time. Stay with us, folks. We got a lot of things that you're going to enjoy hearing about in the second part of the show.
Jim Bohannon, weeknights 10 p.m. to 1 a.m. on AM 1060 WMEL.
This is Joe Steckler, folks. We're back live with the second half of our Thursday afternoon show, Helping Seniors. The show is designed to inform, educate, and connect seniors and those that care for seniors with the many wonderful resources that we have in Broward County to help them. Part of that information and education is doing exactly what Bill and I are doing today, talking about special needs trust, talking about things that you just don't realize that could happen to your house, and by what you could do to hurt members of your family by being overly generous to them upon your death. And it's just something so many of us don't understand, and it's the part about estate planning that nobody really wants to talk about. And I admire Bill for talking about it, because it is something that is not really discussed or written about unless you go ask an attorney. Am I right, Bill?
True.
That's exactly right. But I always want to mention my sponsors for the second part of the show, which include Senior Scene Magazine, Hometown News, Spotlight Magazine, Seniors Helping Seniors, The Fountains of Melbourne, Courtney Braswell, Barbara McIntyre, who is a reverse mortgage specialist, Canadian Meds of Melbourne, Ear Care, Vitas Hospice, Handy Pro and Space Coast, Aldea Today, and our newest one, which is the Barefoot Bay Tatler. I'll have my first column in there in August. I've already submitted a column to them. I just didn't make it this issue. It'll be in August. And I want to mention somebody else that's a lady that took over in the House of Representatives, Debbie Mayfield, when her husband passed away. She took his seat, and she has done an admirable job, as won re-election in her own right as a representative from down in the Vero Beach area. But now with the redistricting and everything, she's competing with Mr. Workman for the Senate seat for this district. And I know Debbie is really working hard to help seniors. And I just want to leave it at that. If you ask me whether or not Debbie is trying to help us, I can tell you some things, and I just don't want to blow some of her campaign strategy over the air. But I'm going to tell you, folks, you'd like the lady because she's trying very hard to help us. And I tell you, just exactly what Bill and I are talking about here on the air today. More of us need to understand it because there are so many second marriages, especially in Florida, and if we don't do the paperwork right, what we may want to have happened will not happen. And I asked Bill a question about trust and leaving money to our heirs, and it depends. I guess, Bill, as you phrase it, whether it's our own money we're trying to leave or it's somebody else trying to do something, different categories. Can you explain that?
What we were talking about is if we had somebody on Medicaid, how do we leave money to them without disqualifying them from receiving benefits? And usually you do that one of several different ways. One is if the person's under age 65 and the money is their money, like they got it from a personal injury settlement or something, and they're on Medicaid, we can do something called a special needs trust. And we set that up. The parent, the grandparent, a guardian, or the court can set that trust up, and then the monies are put in that trust, and the trustee of that trust can purchase things for that person without the monies in the trust counting as an asset to them and disqualifying them from getting public benefits.
Let's put it in this thing. I think we got a lot of people in my age group, late 70s, early 80s, that may have grandchildren they want to protect, and no, they don't have a lot.
Let's talk about that, because that would be the next kind of trust.
Okay.
Now, if it is not the individual who's receiving Medicaid's money, like maybe it's their parents or their grandparents who want to leave something behind, they can set up what we call a third-party special needs trust. This is a trust that would supplement the public benefits the individual's getting and not supplant them. Now, this can be set up by anybody, any relative or friend even, and you can nominate your own trustee. The biggest difference between these two kinds of trusts is, one, whose money was it? Is it the Medicaid individual's money, or is it somebody else's money, like their parent or grandparents' money? And the second, too, if the money belongs to the individual and we have to set up a special needs trust, then that trust will also have a payback provision to Medicaid. So if it's the disabled or disabled individual who's receiving Medicaid, if it's their money, we got to have a Medicaid payback provision in that special needs trust. If it's not their money, it's a parent, grandparent's money, then we can set up a third-party special needs trust, and that does not have to have a Medicaid payback provision.
Okay.
Now, if the individual's over 65, we can't do that special needs trust for them, but we can do something, regardless of age, called a pooled trust. And this is a kind of a special needs trust run by a charity. It does have a Medicaid payback provision in it, but regardless of age, we can move assets into there. The trustee of that trust then would buy stuff on behalf of the individual.
You keep mentioning Medicaid payback period. Let me see if I'm on track with this. By Medicaid payback period, you mean, let's say that you sent $250,000 up in the special needs trust, and you wanted to ensure that person, say it was 50, 55 years old, you wanted to ensure they had an income the rest of their life.
Well, you don't give them money. You want to provide for things for them. Because if you start giving them money and they go over the asset limit, remember the asset limit for Medicaid is $2,000. So you got to keep that in mind. You can't just give them cash and then they go over the asset limit and they get thrown out of the program. So what we're
how would you do that? How would you
buy things? If the person needed a car, you would buy the car.
Okay.
If they needed a TV, you buy the TV.
But what if a family had a child, and they was say, let's say 55, and you knew that they had not worked and probably wouldn't have Social Security. They probably didn't have anything themselves. So you wanted to make sure they had an income.
Now, this child's disabled, right? And on
No,
Medicaid?
I'm not talking about somebody not disabled. Not disabled.
Well, then there's no rules. Then you just leave it in a trust and have the trustee dole it out to the kid any way you want.
But let's say...
Or you could leave it directly to the kid. I'm talking about if the kid is receiving public benefits that are means tested, like SSI
okay, I understand
or
what you're
Medicaid.
saying there. So there are just so many situations that I guess what it comes down to is that each situation has to be looked at on its own merits.
Correct. And if you have somebody that you're leaving money to that is receiving means tested benefits, like SSI or Medicaid, you really do need to go see a lawyer because that will require some special planning. And
I can see that based on what we're talking about.
Because you don't want to
today.
just leave the money to them outright. They get booted out of the program, and then we got a huge mess to deal with.
Yeah, because that money that you give them wouldn't be enough for them
And
to
I'm going
live
to tell
on.
you about something that you probably didn't know about, Joe. July 1st.
Try me.
July 1st of this year, we have what they call ABLE accounts in Florida. And these have just been authorized. They started July 1st of this year. You can find them if you go to ableunited.com, which is Florida's ABLE account
Terry, get this written down.
website. Yeah.
Say it again.
ableunited.com.
Okay, ableunited.com.
Okay, and what an ABLE account is, it's like a 529 account for somebody with disabilities. You can put up to $14,000 a year into an ABLE account for somebody who is disabled. That money will sit in that account and grow tax deferred. And when the individual pulls it out, they have control of that money. And so
Can't
they
pay
can
taxes
use
on
it.
it then?
I believe they would have to pay taxes if it grows tax deferred, yeah. But they can pay and buy things, but the money that's in the ABLE account does not count as an asset to them. Basically, it's a way of kind of doing a special needs trust without having to go to a lawyer. So
If you go to a lawyer and do that, that's another way to sort of get around what I was talking about earlier. Say if you had somebody, you wanted to make sure they didn't spend that money till they got to be in their 65s to 70s, you could put it in that ABLE account.
Yes, but only up to $14,000 a year. So you could maybe, one thing you would do is you create your own special needs trust. And then when you wanted to give that individual money, you would put the $14,000 in their ABLE account, and then the disabled individual could spend the money in the ABLE account any way they wanted.
Folks,
So there's a lot of different planning opportunities that have been opened up. Now, to qualify for an ABLE account, you've had to have been disabled prior to age 26. Okay? So this is not something that we're going to be pushing on a lot of seniors unless they had a lifelong disability. But it is something new that's out there, and if you have a disabled child, somebody who's had a disability prior to age 26, this certainly is a great development for you.
I was thinking of a case that I just recently heard about. The man is bipolar. He's in his very, very early 50s. His wife divorced him, and he is disabled, and he lives on disability. And I have no idea what the man's income is, but this is the kind of thing
He could apply for that if he could prove that his bipolar disorder occurred before age 26.
Wow.
Yeah. So you don't have to be under 26 to have an ABLE account. You just have to be able to prove your disability occurred prior to age 26.
Or something happened to you that might have affected you in later life.
Which caused the disability, but
And
it
there
has
are
to
a
be
lot
prior
of-
to age
yeah.
26.
There's a lot of things that could happen to a youngster
Correct.
that would cause that.
Correct.
So, folks, what we're talking about is we get back into it.
And it doesn't necessarily mean that there is a procedure that if you do not have a disability determination from Social Security, there is a procedure you can go through to document a disability prior to age 26 without having to go through the Social Security system.
See what we don't know, people?
And this is all hot off the presses as of July 1st of this year.
But Bill, it's all the more reason for us to talk about it on this radio show. It's just like when I first saw Bill here in the station, folks. We both got here about 15 minutes early. I asked Bill about the SHIP program. Now, most of you, when you hear me say SHIP, that doesn't mean a darn thing to you. You don't know what I'm talking about. Seniors Health Insurance Planning is what it is. You know it as the SHINE program, serving the health insurance needs of elders in Florida. What you don't know is that when that provision was attached to the Social Security Act, it said they put in roughly $50 million for the entire United States to run the SHINE program. Another state, each state can call it what they want to call it, folks. We call it SHINE in Florida. But those 50 states each have a program, and they get roughly $1 million each. That pays for the brochures and stuff. They have about 4 or 5 people that run the program in each state. But the 14,000 people that do the SHINE planning are all volunteers. And Lance Jarvis, who is the volunteer coordinator for Brevard County, is just heartbroken because this program has been defunded by the Senate. So,
and it's not a program that wasn't used.
God,
it was
no.
used
It's
very
used.
much.
Yeah, think, folks, of all the times you've heard me talk about SHINE on this radio station in the last 16 years, and how many people, when this Affordable Care Act thing broke, and when they talked about if they had a name for the people that you were supposed to go to, a lot of those people went to the SHINE people to see what they really needed to. And the SHINE people, they don't have any allegiance to Republican, Democrat, or a darn thing. They're just having allegiance to helping you, seniors of Florida.
Well, what they would do is help people navigate the Medicare Advantage plans and choice plans, Medicare A, B, C, D. They would also help people look at the supplements. They would
get into the right insurance program.
Yeah, they would help people with long-term care insurance. They would help people navigate this whole maze of insurance programs, which can be very baffling for somebody who doesn't really know what they're looking at.
Yeah. Folks, if you want to get involved, here's what I think you can do. You can write a letter to Representative Posey. You can send a letter to Senator Rubio or Nelson. Or you can write to members of the Senate Appropriations Committee. I've got one member of the committee I intend to write to. I have talked to several other people about writing to Washington to try to get help on this, because if we don't fight for these things, this is why we talk about things like this on the radio show, Bill.
Right.
You know,
I mean, they do a lot of good work.
A lot of good work. Yeah. You know, at the break, you said something about you had something else you wanted to mention on the House, or did we cover?
Oh, I just wanted to mention that, you know, when you're looking at the planning for the House, you have to take into consideration not only the estate planning, and then you have to look at whether or not the individual is going to receive Medicaid benefits. But one of the things you had wanted to talk about was reverse mortgages.
Yeah.
When is that a proper time? And generally speaking, I only advise my clients to do a reverse mortgage if it's pretty much the last option. Basically that they have no other resources they can turn to. Whatever resources they are getting aren't sufficient to meet their care needs at the house or, help pay for the bills, and that they really, really, really want to stay in their house and there's no other way to generate any income.
We do the same thing, and that's the same thing that Barbara McIntyre recommends. But think about this for a minute. A lot of you seniors, you have an older home, and a lot of you have called Kay at the office and said you need financial help in repairing your roof. Heck, you could take a reverse mortgage out, a small one on your house, just enough to cover the cost of the roof, and that's not going to hurt you at all. All it means is if you own a $150,000 house, it just means that you can take probably up to 50% of the value of it in a reverse mortgage. But it means that you can get your roof fixed. What it means is that you stay dry, and maybe the people you want to get the house to a year or two after you pass away, they just don't get the $2,000, $3,000, or $4,000 it costs to keep you dry for that time. So think about it practically, folks.
Also, the value of your house would go up.
How's that?
Because you put a new roof on it.
Oh, okay. Yeah.
So
See, this is why you should talk to an attorney, folks. I didn't think Bill was this smart. I mean, he keeps pulling all this stuff out of his hat. That's what an estate planning attorney does. He pulls things out of the hat. There's one thing left I want to talk about, and that goes into the area of digital assets and the fact that they're a growing challenge in estate planning. And I asked Bill what in the thunder they meant by that. Bill, tell us.
So for Joe's generation, we'll talk about digital assets. Digital assets are basically anything that deals with a computer, whether it be your email, access to your computer, your web page, your Facebook, your social media, your Facebook, Twitter, all those pages, online banking.
That's a big one, online banking.
Correct. And what we're really talking about is if you become incapacitated or die, who should have access to those assets? If you're like me and you post a lot of your pictures on Facebook, and then all of a sudden I pass away and my daughter wants to go on Facebook and download all my pictures, is she going to be able to do that? Does she have the permission? Is she going to be able to go on, if I become incapacitated, go online on my online banking and get the password to do banking online? And who would own my webpage, or who would manage my webpage if something were to happen to me? So in this digital age, we have all these digital things we're doing, and these things are all referred to as digital assets. Now, July 1st, we had a new law that went into effect in Florida that deals with kind of a default. If you have not made arrangements with whoever hosts your digital assets, whether it be Facebook or whoever hosts your webpage or your bank, on some sort of survivor plan, who can get access in case you're not available, then there is a statute now that tells your executor, your trustee, or your guardian, or your power of attorney how to go about getting access to those assets.
So they made provision for
a default.
A default.
Basically. And they have to go in front of the court, and it's not, quite as simple, but they do have to get court permission to.
You'd need an attorney to do that.
You probably would. But if you have made arrangements with your Facebook, Twitter, or whoever it is, then those will control.
But you can make arrangements to do that?
Yes. You can provide for succession planning.
Where does somebody go to find out about all that?
Well, you do that right on your Facebook page, right on the company.
Carrie Fink, if you're listening to this radio show today, and I know you are, I'm going to be asking you some questions about all this stuff you got me going into on Twitter to sell tickets on that Jaguar.
Yeah,
so I want to mention that, folks. We're raffling a 1992 ruby red Jaguar. It's in beautiful condition. It's got 38,000 38,000 miles on it. I think that's right. And it's gorgeous. We're going to raffle off on the 6th of December. So we're selling tickets. You can call Kay, $25 for a ticket or $5 for $100. Somebody's going to win a beautiful 12-cylinder Jag. It's got a long, low front end. You go to our website, helpingseniorsofbrevard.org. It's got a beautiful picture of the car stand with the door about to shut on me. And but take a look at it. It's just how we pay our bills. Thank you, Bill, for being on the show today. I appreciate what you say. And we're out of time.